Welcome to the Flex Your Rights podcast. I'm your host, Corey Hanrahan. This is the podcast for informing employees of their rights in California. So if you want to know your rights so that you can flex them at work, this is your show. Let's get flexing. All right, everybody, welcome back to the Flex Your Rights podcast. You've got me again, attorney Corey Hanrahan, with my man Travis Triggs. And we've got a special show today, Travis's idea, to talk about something that a lot of people are unaware of or unfamiliar with, class action lawsuits, right?
Yes.
A little bit more infrequent than your regular just individual lawsuits, but Travis thought it would be a good idea to talk about, sort of the difference, why they exist, and some of the nuances of those class action lawsuits. So I said, let's do it. Let's educate everybody on how they work in case you get one of those notices in the mail that, your employer or former employer you worked for is getting sued for a class action. And you get the old question of, do you want in, right? Do you want to participate or not? So let's talk about it, Travis. Let's cover class actions, man.
You know what's funny? That now that I'm sitting here thinking while you were talking, and like a class action lawsuit, I've actually been involved in a class action lawsuit.
Oh, no way.
Not me particularly. Well, yeah, me particularly because I got a check. But I just remember a mailer coming in the mail for a job I had, and it said, "Were you hired at this job from this time to this time?" And it said, "Yes, file your name." I think I had to put when I was working there, and I signed it, sent it back, and like a few months later, I had a check came in the mail. Like that was just saying, I'm like, oh wow, yeah, I did participate.
That's it. And maybe we'll talk about it, Travis. So Travis has questions for me.
Yep.
Maybe we'll talk about it. Maybe we won't. But there is sort of that notice that you get in the mail. And let's just talk about it. It's a little backwards, right? So the notice is not a, hey, do you want to participate? It's really a, hey, do you not want to participate?
Yeah.
So normally it's an opt-out notice. So yeah, right. So it's a little backwards. So it means that you're really included in the class action, right? So, you are part of the class action unless you respond pursuant to that notice saying that you want to opt out.
Oh.
So you're not saying I want to participate. You're saying I don't want to. And so why would you not participate? Maybe you've got a lawyer that you're already suing for on an individual basis or something like that, and you don't want your claims to be resolved through the class action. So look, maybe we'll talk about that. But I thought since you brought it up,
dude,
only prudent to let you know that those notifications are, if you don't opt out, your rights are going to be affected by this class action settlement. So you're not opting in. You're opting out generally, but you'd have to read it. Anyway, Travis.
Okay. Oh, man.
I stole your show, man.
Oh, your show, brother.
Hit me with the questions.
So let's hit you with the questions. So the very first question about a class action lawsuit is, what is it? Can you explain what a class action lawsuit is and how it's different from an individual lawsuit?
Absolutely. So a class action lawsuit is a lawsuit that's seeking damages, right, on behalf of a class of people, so a group of people. So unlike an individual lawsuit where you are suing only for your damages, you can file a class action lawsuit under certain circumstances, and you are suing for your damages and any of the other potential class members. So like you said, people who worked for a company from this date to this date, right? Because there's normally, the class period is defined as, people in this certain role working for this company from this date to this date. So, there are qualifications on who can be a part of it. But if you fall within that class period and the potential class members, then it's seeking damages, not only for you, but for all of basically your other coworkers who got screwed too. Okay. I mean, that's what it is. You're saying, look, I'm going to vindicate my rights and everyone else who was treated similarly unlawfully. And so that's the difference. You're not just looking out for yourself, you're looking out for others.
Okay. And then what are the criteria that need to be met for a lawsuit to be considered a class action lawsuit?
Oh, so that's a little complicated, right? I mean, not really easy, to go into on a podcast and explain it because it requires an analysis. But there's, generally two things that you want to think of. Are there enough people? Are there enough affected people? So that's called numerosity, right? are there enough other coworkers who are also impacted by this? And, there is no magic number. I mean, there's sort of guidelines that, that lawyers think of when looking at class actions. But, if you call up a lawyer and go, it's myself and my, three other coworkers, we're the only ones here and here's what's happening. That's not going to be enough. That's not going to
Okay.
be enough for a judge to say, you know what, I think it would be best to handle this as a class, because the idea behind class actions is, you're able to easily resolve a bunch of people's legal violations. You know what
I
I mean? They
see.
seek to get recourse. And you go, judge, if we've got to do these individually for all these people, there's going to be 100 different cases. It's more economic and efficient to do it as a group. And so when there's only like 3 or 4 people, the
You could
judge is
just
going to go,
individual.
well, no. I mean, there's not that many people. You can do it individually. So numerosity is one key, right? How many people were affected? Were there enough? And the second part, I mean, there's 3 or 4 or 5 parts, but the other important part is, did everybody suffer from the same violation? Right? Did everybody suffer from the same violation? So that's sort of considered like, commonality or common issues of fact in law, right? Where they all subjected to the same thing, because you want to be able to prove sort of a policy at the workplace where the rights are being violated um, in the same way. So
It's
that's
kind of like
kind of the that's
it's
kind of the question, right? Are we all suffering from the same thing, and are
yeah.
there enough of us? I mean,
It's
and
it's kind of like, I'm so sorry. I'm like trying to say, like, it's kind of like something that you're saying. It's kind of like if your job's not giving everyone their time off, like everyone's not getting lunchtime, everyone's not getting that hour of the day, like they're forced to work, and everyone on the same line, like, no, you're not taking your lunch until this is done, and everyone is dealing with that.
that's
That's
a
like
good
an
example.
example.
That's a good example. So you brought up, meal breaks, and I'm going, oh, bad example, Travis, and I can tell you why. Because an employer only has to provide the ability for employees to take a lunch. They don't have to
Oh,
make them, right? So
ah,
with class actions, if you get into a situation where you're like, it's too busy. I can't take one. A judge may go, well, but there's an individual question for each employee on whether or not they were too busy to not take one, or if they just voluntarily decided not to, right?
ah,
But in your example, where it's like, we're not giving you breaks, you can't take one, you're going to work through it, then yes, great example, right? Everybody is having their meal period, lunch break rights violated in the same way. They're being told, no, you can't. And if there are enough employees at the company that's you know what I mean, that you're able to
wow.
meet the numerosity requirement, bingo. I mean, that's a good potential class action lawsuit.
Okay, okay, perfect. So let's see. We're gonna keep moving forward. That was a thank you. Numerosity. You taught me a new word today. Numerosity.
Numerosity. Numerosity.
Numerosity. Okay, in your experience, what are the most common types of class action lawsuits in the realm of employment law?
I would say wage and hour.
Ah,
Wage and
okay.
hour. So, you already brought up the lunch breaks, like, lunch breaks, meal breaks, maybe not being paid overtime. There have been a lot of cases in the past where, employees were required to get to work, change into their special uniform that they're supposed to, and then clock in. So there have been lawsuits about, well, if I'm required to change into this and it's at the employer, right? I should punch in first and then
Yeah.
change into it. Those
Yep.
sort of things. And so, the wage and hour are probably the most common type, because if you think about a discrimination or wrongful termination, that only usually affects like one person.
Yeah.
You know what I mean? Or maybe a couple. But, the wage and hour are generally, bad policies employer wide across the board. And so if one person is being, subjected to unlawful wage and hour practices, others probably are too. So that would
Okay.
be it. When it comes to employment law, that would probably be
Wait,
the most
no.
common.
Okay. And then what are the advantages of pursuing a class action lawsuit for employees?
I mean, the benefit is, I would say twofold. I would say one would be efficiency. You know what I mean? And being able to address violations for a large group of people, as opposed to having to do it one by one for each employee. So efficiency is one. And two, I would say, is probably the impact that it can have on the employer. You know
Oh
what I
yeah.
mean? Class action lawsuits can be expensive for the employers to defend. You know what I mean? They can be expensive when it comes to having to pay a settlement. And so I always look at it like those class actions are probably the most likely sort of lawsuit to affect change at the employer, right? To change
Okay.
their actual policies. Because, you hit them in the pocketbook, you hit them where it hurts, and they
Yeah.
finally go, man, we better change this, right? We better make sure everybody's getting their meal periods, their rest
Yeah.
breaks, overtime, because they don't want to get hit with another one of those because they can be costly.
Like, oh man, we actually have to care about the people that work here now. We actually have
Man, now
to
we got to care about them.
we got to care
Exactly.
about them.
Exactly. Well, even if it's not even caring about him, it's we got to look out for our bottom line. So we've got to
Yeah.
start following the law so we don't have
Uh,
to keep writing out these big checks for screwing things up.
I love how you said that too. That's the thing about a job itself. A lot of people, I think, kind of get it misconstrued to a degree. 'Cause especially you invest so much time and energy. When you're at a job, it's really not about them liking you. It's just about if you're doing the job or not. That's really it. There's really no like in that. And if you feel like that someone doesn't like you, it's different from you're not doing your job. Like,
Absolutely.
and that's one of
Absolutely. Job is a
oh,
job, man. A job is a
e-
job.
exactly. So let's see. So what is the role of the lead plaintiff in a law action? I mean, a class action lawsuit. Like, what's their role for the lead plaintiff?
Yeah, so their role is really the same as it would be in an individual lawsuit. You know what I mean? It's, you're the one working with the lawyer to give them the information. You'll be the one helping answer written discovery. You'll be the one whose, deposition is taken along with maybe some others. So you kind of serve as like, the champion for the class. You're kind of like stepping up. You know what I mean? You're Tom Brady. You're going, you know what I mean? I got the team on my back. Let's do this. So you're the one who's taking the initiative to, initiate the lawsuit and, work with the lawyers to be able to, either get to a trial for a judgment or a settlement. You're the point of contact for the lawyers.
Okay. And then, um, with your professional, this is what you do for a living. So I have to ask you, your professional knowledge. How should that person be selected? Should they be selected by like? Is there a particular way the group should select them, or what are your thoughts?
So generally what happens is they're not selected. Normally
Mm,
they're the person who came to the lawyer and
mm,
said, here's what's happening at work. Right? Because somebody
okay.
has to be the lead plaintiff
Someone
on the
has to take the
lawsuit,
action.
right? So
Yeah.
they have to be the lead plaintiff on the lawsuit, meaning they have to have hired the law firm to represent them on behalf of themselves and the class, essentially. So normally that person isn't picked, right? Normally that's the person who took the initiative to go to the lawyer's office and go, here's what's happening to me. Do you think you can help us? And the lawyer goes, this sounds like a good class action. And then they serve as the lead plaintiff, often called the class rep. So they're not necessarily picked.
Okay.
They kind of make themselves available by initiating the contact with the lawyer, and then they find themselves in the position where it's like, all right, you know what I mean? I'm leading the team. Let's
Yeah.
do it.
So it's basically the person who takes that first action. The one who takes that first step is you're the lead.
Right.
Perfect.
And look, I mean, maybe there's some issues with the person. Maybe they don't make the best lead plaintiff, in which cases sometimes, there'll be multiple, lead plaintiffs. And maybe they'll go, well, my buddy so and so, she worked over there too. Let me have you talk to her. And maybe that person, for whatever reason, would be a better class rep. And so they'll be the class rep or one of the class reps. But again, generally, it's whoever reaches out to the lawyer and says, we've got a problem at work.
Okay. And then, how do class action lawsuits impact employment practices and policies at large corporations and organizations, or organizations?
Yeah, again, I would say that, this is my opinion, right? That they are the most likely lawsuits to affect changes in policy,
Okay.
right? They're the ones that get the attention of the people at the corporate offices who are in charge of policy making, policy decisions, and get them to go, okay, look, we don't want this to happen again. We don't want to get hit with another $20 million lawsuit. You know
Yeah.
what I mean? And have to write all this money out. So let's change our policy so that it reflects what it's supposed to make sure that this doesn't happen again. Now, look, written policy is sometimes different than what's actually implemented. I
Yeah.
see that a lot in what I do. There's a policy that says this, But in practice, the managers, general managers, regional directors, whoever they may be, are not following the policies. So a
Okay.
solid policy doesn't keep you out of trouble. It's really the policy mixed with training the people who enforce it to make sure that they're enforcing it per the policy.
Okay.
Um, but I think class actions, they really can hit a company hard in the pocketbook, and that's what makes
Yeah.
them stand up and take notice.
Okay. And then, so for the arbitration, so how do arbitration agreements affect the ability of employees to participate in a class action lawsuit?
Okay. So I am not a huge fan of arbitration agreements, right? I
Okay.
mean, I don't know if you know what they are, Travis,
Yes.
necessarily, but let's
Let's
talk
say
about it.
what. Let's start with what is what is arbitration
Okay.
agreement?
So everybody watches TV. They watch the TV show Suits, and there's always a trial in front of a jury, right? And the
Yep.
lawyer's standing up talking to the jury, going, "Ladies and gentlemen of the jury, thank you for your time and attention," and yada, 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 right? I mean, that's what everybody thinks of. If you
Yep.
have an arbitration agreement, you are stuck in the arbitration forum, not the courthouse. So there is no judge, there is no jury.
Uh,
There is a retired judge or sometimes retired attorney or maybe practicing attorney who hears the evidence and decides who wins and how much money you get.
oh wow.
Right. And look, employees normally do not want them. They are forced on employees by the employer
Oh
because the
wow.
employer generally knows an arbitrator, right? A trained legal person is not going to give or is less likely to give a runaway verdict like a jury. A jury
Mm-hmm.
could be super pissed off about something an employer does. And, they could be like, here's $10 million.
Yeah.
I can't believe what happened to you. An arbitrator on the same facts could be like, I can't believe what happened to you. I'm so sorry. Here's 100,000.
Yeah.
You know what I mean? Like, cause they think with their mind, not so much with their hearts like a jury would. So an arbitration
Okay.
agreement means you don't get a jury trial. You've got to have an arbitrator decide if you win or lose. So now with regard to how they affect class actions, those
Yes.
arbitration agreements now almost always say that you waive the right to bring or participate in a class action.
Oh wow.
And that is enforceable. So
Wow.
that's one thing that you need to know. If you sign one of those arbitration agreements, you probably do not have the right to bring or participate in a class action in any way.
That's interesting.
It can preclude you from doing so.
Oh,
And it,
that's really smart. I mean, that sounds bad, but like for a business owner's perspective, I guess that's smart because it pretty much says you guys can't go no further than this. Pretty much, right?
well, you would have to bring it on an individual. You'd have to bring your claim on an individual basis, not class action, and you'd have to do it in
Okay.
arbitration. Now, look, there is a downfall to it, though. If there's employers out there listening, going, "I'm going to make everybody sign an arbitration agreement. This is going to be great." The problem is in California. So under California law, the employer has to pay for the arbitrator, who would otherwise be a free judge or jury. I
Yeah.
mean, you have jury fees, but you're talking several $100s a day. That's it. Arbitrators can be anywhere from $100 to $150,000
Oh
for like the
my
course of the
gosh.
arbitration. So it's there.
It's gonna
There.
sting.
Yeah,
It
there
st-
are.
it still
Yeah, there. So
stings.
there is a downside to it for employers, and that would probably be it. The cost. Because if you have that arbitration agreement and the employee says, "Hey, I want to do arbitration, let's do it," you're going to have to pay a big chunk of money for that arbitrator, win, lose, or draw.
Oh wow, that's
And
good
so,
information right
yeah,
there. That's
yeah.
good to know. Well, guys, I hope that we were able to go over some valuable information. So if you're either involved in a class action lawsuit, if you're planning on putting together a class action lawsuit, I hope we were able to give you some information and you understand that numerosity, you got to have
There's
a
that word,
certain,
Travis.
yeah, there's that word.
Numerosity.
You got to have a certain amount of people. You have to have a decent amount of people involved to make it an actual class action lawsuit. But thanks again for timing in. Corey, you can go ahead and tell these people what they need to know and how to contact you, brother.
Yeah, I appreciate it, Travis. You can find me, hanrahanfirm.com. You can find me, attorneycorey.com, Corey. Find me on social media, at Attorney Corey. Pretty easy to find. If you've got questions, reach out. If you've got an idea for a future episode that you think would be a good topic, that's something that you've been wondering about at work, reach out. Let us know. We're happy to do an episode on it. We have a lot of fun with these podcasts. I appreciate you listening. Again, the purpose of the podcast is for you to know your rights so that you can flex your rights at work to make sure you're not being taken advantage of. And that's why we are here to help in that regard. So have a good day. Reach out with any questions, and don't forget to flex your rights.
Your rights.
Thank you for listening to Flex Your Rights Podcast, the podcast to educate California employees so that they can flex their rights in the workplace. If you'd like to reach out to me to ask me any questions about today's episode or make a suggestion for a future episode, you can find me at attorneycorey.com. That's attorneycorey, COREY.com.